So good afternoon and good evening, everyone. Thank you for allowing me to present to you today, this afternoon, this evening. My name is Craig Waldie. I'm a senior geologist with the Ontario Securities Commission. I've been with the OSC since 2006, almost 19 years now. So this is my second go around of revisions that have taken place to National Instrument 43-101. So my main role at the Commission is reviewing technical disclosure by mining companies, so exploration companies, companies at the advanced stage, or companies in production, and reviewing that for compliance with 43-101. And prior to joining the Commission, I spent about 20 years in industry, mostly with larger companies, BHP and Phelps Dodge, and then a couple small juniors where I was VP exploration for a number of years. So the title for the topic today is a little bit different than what was in your introduction, but the materials are the same. So it's proposed revisions to National Instrument 43-101, and that National Instrument itself is called Standards of Disclosure for Mineral Projects. And just want to note that these are just proposed revisions. The existing 2011 version is still the version that's in place and that we review disclosure against. So I'm not sure how many people are overly familiar with 43-101, so that's why I'm going to do a little bit of the Canadian landscape and a tiny bit of background, and then move into a high level of the proposed changes. So as with any presentation we make, I need to provide some cautionary statements that these are the views of myself, not necessarily the views of the Commission. It's only for your background information. It's summarized from the legal documents, so it's only summarized from for presentation purposes. And as always, the disclosure is the responsibility of the company to comply with the disclosure requirements. So what we'll cover at high level is we'll start off with the securities commissions in Canada, because that is Canada's unique that way. Maybe not unique in a good way, but definitely unique. And a little bit of background on 43-101, National Instrument 43-101, and then move into some of the proposed changes and a slide or two on next steps. So to start off with, we'll move into the first topic, which is securities commissions in Canada, and a little bit of background. So Canada is different than almost every G20 country with regards to how securities are regulated. So securities are regulated within 13 individual provinces within Canada. So each province has their own securities commission with their Securities Act. They each have their own act, but they regulate against national rules. So there is standardization across Canada within the rules, but each commission, each province has jurisdiction over the companies that are located within that province. And the commissions have been generally funded through market participation fees. It's not publicly funded from government agencies, it's through participation fees. But because we have 13 commissions, one way we have to sort of organize is, well, who is the regulator for that company? Because a company could be based, say, in Vancouver, the projects are all in Mexico, like who regulates that company? So it's based on where the company's head office is. So such as Barrick is located in Toronto, so they're regulated by the Ontario Securities Commission. Teck is based in Vancouver, in British Columbia, so they're regulated by the BC Securities Commission. And BC and Ontario are the two large jurisdictions that regulate almost 1,500 mining companies. So when you look at the total number of companies globally, approximately 55% of them are regulated either by BC or Ontario, no matter where their projects are located. So what Canada does to help some harmonization is they have what's called the Canadian Securities Administrators. So they help to harmonize, organize the provinces to make sure that they are singing on the same hymn book with regards to how the rules are put together, and they help organize the national instruments. So that's sort of how Canada works, which is different than, there's no SEC like in the US. It's 13 different commissions. So National Instrument 43-101, at a very high level, this slide just shows the sort of the overall objective and the approach, like how the objective is achieved. So the objective has been to basically enhance the trust and credibility of mineral project disclosure that's made to the public. So enhance the trust and credibility of the disclosure, to foster accountability of professionals for their judgments and opinions regarding the mineral project, and to empower investors to make informed investment decisions. So it's ultimately up to the investor to decide whether to invest in a company. The idea is that the disclosure should be sufficient for an investor to make that decision. And how this is achieved is basically each issuer's mineral project disclosure must be it must be prepared by a qualified person or a competent person, as whatever jurisdiction you're in, as in JORC or PERC or the SEC uses qualified person. Most of the jurisdictions use competent person. Same thing. So issuer's mineral project disclosure must be prepared by a competent person or qualified person. It needs to be understandable. It needs to use standardized terms and definitions. It needs to be balanced, so provide all the positive and negative information related to the risks and uncertainties of the project. And it needs to be verified or reliable. That the information has to be something that a QP or qualified person or competent person has verified that's reliable. But there's a misconception with same thing with JORC and 43-101 is that a lot of people wrongly believe that a National Instrument 43-101 technical report somehow certifies that a project is viable. And it doesn't do that. It just is a mechanism of providing disclosure to the public related to what the company's been doing and what the qualified person's been doing. So it's just a disclosure regime. It's not a certification regime. So just, I'll briefly go over this, but 43-101 came into effect in 2001. So it's been 24 years. And that was based on the recommendations of the Mining Standards Task Force that came out in 1999 after BRIEX, which happened in 1997. There was minor modifications in 2005, and then I came in 2006. So I was there for the second revision, which was in 2011. The biggest change there was in the technical report form itself and how that was put together. There was also unfortunately, a change made to preliminary economic assessments that end up being misused, sort of unintended consequences that we need to put out a CSA staff notice a year later in 2012. And now we're going through the third revision, so the 2025, 2026 proposed amendments came out on June the 12th for a 120-day comment period, which ends in mid-October. So one way that 43-101 also is a bit different is that there is a strong linkage or partnership between the securities regulators and the Canadian Institute of Mining, Metallurgy and Petroleum, CIM, on this slide. So part of the requirements are set by the regulators, that's above the dashed line, and part of the requirements are set by industry itself. That's the material below the boxes and the circle below the dashed line. So in the blue boxes, that's the law requirement. So this is the you must requirement of 43-101. So there's the national instrument itself, which sets the rules for disclosure and technical report triggers. And you can see a box below national instrument that comes from the industry side that says CIM definition standards. So when CIM puts out their definition standards, they're directly incorporated by reference into National Instrument 43-101. So National Instrument 43-101 doesn't include a definition for mineral resource. We take that from what CIM has published in their definition standards. Then also part of the blue box is the form for technical report. So a technical report has a prescribed format that must be followed. And again, that is part of the legal requirement. And then there's the sort of the beige circles. So that's the guidance documents. So there's a guidance document that is directly related to National Instrument 43-101. That's called Companion Policy 43-101 CP. So that's sort of guidance that the regulator puts out with regards to how the rule should be interpreted. And also referenced in that are the CIM practice guidelines. So mineralization, mineral resource reserve estimation, metallurgy best practice, environmental leading practice. There's a number of practice guidelines that are again referenced in National 43-101, and this is the should be followed component. So it's not a legal requirement to follow the companion policy, but it sets out the guidance for the rules. And then at a high level, there's three core principles. The foundation, of course, is the competent person. In our regime, it's called the qualified person. And they're really the foundation of 43-101. The whole system would fall apart if the qualified person or competent person didn't understand its critical gatekeeper role in public protection and maintaining confidence in the capital markets. Then there's the CIM definition standards and best practices, or our leading practices, which are a core component, as I showed in the previous slide. And then the technical report, which is a requirement that is been in Canada since 2001, and recently with the SEC SK 1300, they also have a technical report summary requirement that needs to be made. So the concept here is basically disclosure with professional accountability placed upon the individual, the qualified person or the competent person. We usually show this slide. It just gives you a very high level look at the tech reports filed since the beginning of 43-101 in 2001. That's the blue bars. Relative to, let's see, we use the S&P annual index metal price. So it's 8 metals to show you sort of where the metal prices are relative to the technical report filings. This is across Canada. And the projects can be anywhere in the world, but they're filed in Canada. So there was during the 2015, well, I guess before that, the 2011 was the peak with the super cycle in commodity prices. Then there was a drop in commodity prices. You can see a corresponding drop in the number of technical reports, because a report basically is required to be filed when a company advances a project. So we say a mineral resource, preliminary economic assessment, mineral reserve, all those stages will trigger a technical report. And then since 2021, metal prices have gone back up, but there really hasn't been a corresponding increase in the number of technical reports filed. Back in 2015, 2016, most of the speculative financing went into the crypto and cannabis market rather than junior mining stocks. I don't think that's where the speculative capital is going anymore, into the crypto and cannabis, but we really haven't seen a corresponding increase in the number of tech reports filed. So that's the summary of 43-101, the Canadian regime. And then now we'll just go into some of the proposed changes. I guess I could take any questions at the moment if anybody has any, or I'll just continue with the presentation.
Question, do you think the number of reports being filed could be due to SK 1300 being introduced as potentially, but we're not looking at one?
You kind of broke up. I think you're talking about what, sort of trying to understand why there hasn't been an increase in the number of reports filed since 2013.
Yeah, so just curious whether it's the 1300 reporting has is competing with NI43-101. SEC reporting versus
Oh, okay. Yeah, the SEC, it came out in 2018. I think it became effective 2021. So it was like, it really hasn't, that wasn't something that contributed. We haven't seen a significant increase in the number of companies, say, delisting in Canada and sort of going to the US as being their home jurisdiction. So that the timing with regards to when SK 1300 came into effect doesn't show up here that we can see. And also Canada still has over There's probably 1,800 mining companies that are, and then the US, I don't know the actual number, but there's much less than that. But yeah, it's something we're not exactly sure why there hasn't been any news, other than companies are not advancing projects like they used to. Maybe financings are more limited.
Okay, thank you.
Okay, so to start off with a little bit of the proposed changes. So this sort of assumes you have a basic understanding of what the rules were, but I'll go through what the proposed changes are. Again, very high level, just hitting on a few of the main points. So what's important to know is that on June 12th, the CSA put out a notice of request for comment. So basically it's, here's the proposed changes. We need your feedback by October 10th relative to these changes. And I'll go over that at the end of the presentation as well. But that's the concept is, okay, here's the proposed changes. We would like comments from the public with regards to these changes. And those will be posted actually on the Ontario Securities Commission website. Not every jurisdiction is required to publish the comments, but Ontario is. So even if it's an email regarding one part of the rule, that would be published on our site, or if it's 100-page summary of the comments and what people agree with and don't agree with. The link below is the link to the Ontario Securities Commission posting regarding the notice, and that's the only. You have to go to the Ontario site to see the cost-benefit analysis because it's only done based on Ontario issuers, not CSA-wide issuers. So at a high level, what we were trying to do was we had sort of four main goals. So first off, modernizing the rule, because it's been 2011 since the last revision. So we needed to sort of update, streamline, and certain disclosure items needed to be eliminated or revised. Right? We set through the passage of time to reflect many things, including how the industry currently works compared to in 2011. We were trying to also harmonize the best we could with regards to the other international disclosure regimes in Australia, Europe, US, South Africa. Definitely not full harmonization, but harmonize where we could. Clarification, basically that means adding more guidance. So we tried to add guidance in the companion policy and maybe make our definitions a bit clearer than they have been. Based on our practice of reviewing companies, sometimes the definitions were not clearly understood. So we added a lot more guidance. And again, the ultimate goal is to preserve, Canada's position with regards to capital mining formation. I think it's really the TSX, the venture, are really the main exchange where mining companies are listed. And 43-101 is one of the sort of leading disclosure requirements. So we wanted to preserve that as well. So we'll look to the changes to the instrument itself. So one of the things you'll notice when you look at the proposed changes is the numbering is different. That was required based on the CSA having a new drafting style for all the rules. We just happened to be probably one of the first ones that had to go through this revised drafting style. So then the requirements are now consecutive. So there's requirement 1, 2, 3, 4, 5, 6, 7, 8. Whereas prior it was requirement 1.1, 1.2, requirement 2.1, 2.2. That's now shifted. So the example shown below, if a company triggers a technical report based on first-time disclosure of a mineral resource, the old numbering system, that was under section 4.21 of the rule. Now that's under 16.1 of the rule. So that's one difference. We've also allowed CIM to take ownership of 3 new definitions. So these are going to be in the CIM definition standards, not in 43-101. So if you want to look for the definition, you got to go up to the CIM definition standards. So there's exploration target. We didn't really have a definition. We just talked about, there was a concept under the rule about a target for further exploration. we need a definition for exploration target. Scoping study, we've proposed to revise the term preliminary economic assessment to scoping study, which is used by all the other jurisdictions. And we're also in a new sort of study type regarding projects in production would be a life of mine plan. So these three proposed definitions were just recently published by CIM on July 11th. There's a link there to those definitions, and they have it open for a 60-day comment period for you to send comments to CIM with regards to those three definitions. So that'll end in sort of mid-September. Well, some other definition changes. The term throughout the rule, we've used the term mineral project, mineral property sort of interchangeably. So we're going to standardize it to mineral project and not include mineral property in the rules, because it became, some people were confused by the two terms. There's some issues in technical report, so we've removed the idea of an early stage project or an advanced project. Again, it was technical reports where we were seeing misunderstanding of how the technical report should be prepared. One of the bigger changes is we've removed foreign codes. So currently the rule allows a mineral resource estimate to be prepared under JORC. And then when the technical report is filed, which still has to follow 43-101, it could say this is prepared under JORC. Going forward, because there's been increasing harmonization within the CRISCO family of codes, we're saying the mineral resource, mineral reserve needs to follow the CIM definition standards. And because in most cases, almost all cases, the CRISCO family of codes has a standardized definition for mineral resource and mineral reserve.
Então, ficaste por trás, João.
And then data verification, I won't go through that. We just sort of relocated it, and we've updated the revenue threshold to be a producing issuer, which just comes into the independence requirement for tech report. That's where producing issuer is an entity, is a thing you need to understand. The revenues haven't been updated since 2001, so based on inflation, we updated the revenue thresholds. QP definition hasn't substantially changed. So this is the competent person definition, but we've tried to add clarity and a bit more guidance. So clarifying that the individual's experience in the minerals industry, which is the 5 years of just industry experience, needs to be gained after professional registration, or whatever jurisdiction your professional association is located. Concept is the individual needs to have at least 5 years after being registered as a professional. We've removed the education requirement because that's covered by professional registration. And we've clarified the requirement related to relevant experience. It's been revised, but the concept is the individual's relevant experience needs to be with the subject matter of the mineral project. So the mineralization style in the guidance document, in this companion policy, we talk a little bit more about what we think of regarding relevant experience. So it's the mineralization style and the activity being performed by the qualified person, by the competent person. Mineral resource estimation, metallurgical recovery, plant design, whatever it is the individual is taking responsibility for, they need to have that subject matter relevant experience. Triggers, we've removed 3 triggers that were not really that weren't really being used anymore. One was the royalty only companies. So companies that only have a royalty. It could be a metal streaming royalty or a cash flow royalty based on they have an interest in a mineral project, but they don't actually own the mineral project. They just have the royalty. Currently, tech reports may be required for royalty companies, we're going to get rid of those. We're getting rid of the rights offering circular because the rules have changed since 2011. It doesn't really come into play anymore. And we've removed one of the Toronto Stock Exchange venture offering document triggers, which haven't been used by mining companies in over a decade. So we're removing three triggers. And some additional clarification. When a company, the way the rules drafted now, it says that a qualified person needs to either prepare or approve disclosure on the issuer's material mineral project. So a company could have three properties, only one's material. The current rule says you only have to have a QP prepare disclosure for the material one. But in reality, all mining issuers, if they're putting out a news release on any of their projects, material or not material, they identify the qualified person that prepared the disclosure. So we're just harmonizing with what actually companies are doing today is they put out, they identify the qualified person for the disclosure, whether the project itself is material or not. That doesn't affect the tech report triggers. Tech report triggers are still only required for material mineral properties. So that hasn't changed. One of the big changes is Canada is still the only jurisdiction that restricted or prohibited disclosure of adding inferred mineral resources to other categories of mineral resources. So you couldn't have measured, indicated, inferred, and then a total line below, which added them together. We're getting rid of that. So we're more harmonizing with JORC, SAMRAC. You still have to disclose the categories separately, but there's no longer a restriction. You can't add inferred to the other categories. We're updating and adding more guidance relative to equivalent grades because there's been quite a bit of misuse of equivalent grade disclosure. We're updating that and increasing the guidance related to that. And we've removed the allowance for a delay in a site visit or delay in the current personal inspection. So that was put into place in 2005 to deal with a particular issue in the Canadian North. That really doesn't come into play anymore. And even during COVID, we didn't give an allowance for a delay in a site visit. So we're basically removing that allowance that's been in place. But so the concept is when a tech report's filed, at least one of the authors has to have completed a current site visit or current personal inspection. Just one of the authors is a minimum. So now we'll look at some of the changes to the tech report form. One of the changes relates to Indigenous peoples and rights holders. So in 2022, we put out a consultation paper on National Instrument 43-101, and we got quite a bit of feedback from Indigenous and non-Indigenous commenters. The main thrust of that was that a tech report should not be the only document or the go-to document related to the issuer's relationship with Indigenous people that are rights holders in the area of the mineral project. That should be part of the issuers or the company's ongoing continuous disclosure. Now, we still have updated the tech report form to accommodate disclosure, but it's not the only location, because we had some people say, well, the tech report should be the only document that people go to, that investors go to find out where the relationship between the Indigenous people and the issuer, the company. But as most people know, that those relationships can change fairly quickly sometimes, and a tech report is only triggered to support technical disclosure. It's not triggered on other types of disclosure. It's just a technical disclosure trigger. So if there's been an issue with rights holders in the area, the tech report still could be 3 or 4 years old and still be current with regards to technical information, but not the relationship with the rights holders. So we've clarified that rights holders includes Indigenous peoples. We've also extended or required more disclosure in the property description to talk about the status of the permits and agreements with the rights holders for the issuer to conduct work on the property. And under item 20, which is sort of the ESG item of the tech report, we've moved to disclosing dates and sources of government-related permits regarding and environmental studies regarding the project. So it's basically trying to potentially extend the shelf life of a tech report, where the tech report would reference where to go to see government-related permits, and those permits should be updated by the government agency itself on their website. So that's the idea. We'll see how that works, but that's the concept. Data verification, we're just clarifying because a lot of data verification was in item 12. And before data verification became exploration and drilling. So a lot of QPs interpreted, well, I only need to verify exploration work and drilling. Regarding metallurgy, I don't need to verify anything. Regarding infrastructure, don't need to verify anything. But that's not the intent. The intent was data verification should be relative to whatever the individual is being responsible for. So we've modified the wording in item 12 that basically to disclose the verification steps taken by each QP that signed the technical report. Mineral resources, some changes, mostly related to changes since 2011, because in 2014, CIM came up with the definition standards, and then 2019, they came up with the practice guidelines related to mineral resource estimation. So we've added some requirements to discuss the basis for the estimate, meeting reasonable prospects of eventual economic extraction, how the classification of each category was determined, like drill hole spacing, sample spacing, identify the actual spacing used to justify the categories, and clearly require project-specific risks, not just general, we're working in the mining industry, it has risks that metal prices could change. So that's not project-specific. So the idea is to identify project-specific risks and uncertainties. Capital operating costs. So again, we're dealing now with advanced projects. So clarifying item 21, which is the capital operating costs, to understand, so the reader can understand how the estimate was determined. The cost estimates were determined. So the requirement now is to specifically include the cost estimation assumptions used, the cost estimate classification system. The example that is often cited is the Association for Advancement of Cost Engineering, so AACE. That's one that is used. It doesn't say you have to use that, but what sort of classification system was used, what's the accuracy of each of the cost estimates, and also include the disclosure related to closure, remediation, and reclamation. And then economic analysis, again, these are for more advanced projects. So this is item 22 of the tech report form. So to disclose both pre and post-tax key metrics, net present value, IRR. So basically make it clear, it should be pre and post-tax. And something else that we've added based on feedback is the requirement that the discounted cash flow forecasts need to use a risk-adjusted discount rate. So not just a straight 5% discount rate for gold or 8% for base metals. So it should be risk-adjusted, reflecting the project-specific risks. So the project location, the stage of development, type of commodity, and the overall current economic conditions. So we're trying to get companies to reflect the actual discount rate, what the real discount rate would be, not just a straight, we'll use 5% for any gold project anywhere in the world. Current personal inspection, we've basically moved it from the introduction section, which was just a subpart of the introduction, to now a standalone item in the tech report. So we've replaced the item 23, which was adjacent properties, with item 23, current personal inspection. So each QP that visited the project would need to describe the activities and the observations they've made when they did the site visit. And adjacent properties can still be discussed in the technical report under the item 7, which is geological setting mineralization. The problem we were seeing specifically with very early stage mineral projects is half of the pages in the technical report related to the adjacent properties, not the property that was the subject of the report itself. So try to remove that closeology concern that it's all about the neighboring properties, not the property you hold. So by removing the actual standalone item related to that, hopefully it'll lessen the discussion related to the adjacent properties. It still can be discussed, but not to the length of a standalone item. And lastly, the companion policy. So we've updated the guidance where possible in the existing companion policy. And the number of pages in the companion policy now are at least 50% more than the current version in 2011. So much more guidance. And that was what a lot of people were commenting when we did the consultation paper. They wanted more guidance on certain topics, certain definitions, certain interpretations with regards to the rule. So we've tried to do that. And we also now, for the first time, have provided guidance on some of the actual items of a technical report. So guidance on preparing a technical report with regards to what should be included in, item 4. Now, the items are required by the rule, but the companion guidance would talk a little bit about put more flesh on the bone with regards to the requirements for that disclosure. And also we tried to reinforce the idea that a technical report is a summary document meant for the investing public. So it's not meant for another engineer. It's not meant to be a catch-all for all the disclosure on a mineral on the property. It's meant to be a summary document. We've been unsuccessful in 20 years of trying to get the number of pages of a technical report reduced, but trying to make that point as clear as we can. The technical report is meant to be a summary document for the investing public. So the last section on next steps with regards to the proposed changes. So we're on this road to revising National Instrument 43-101. So in 2022, we came up with a consultation paper. We had 38 questions and we had 85 comment letters come in. So in consultation paper in 2022, 2023, we assessed the feedback. 2024, we started drafting the proposed revisions. This is it always takes years. A lot of people think, why is it taking so long? It just does. It takes years to follow this whole process. 2024, the policy work began. And then in mid-2025, we came out with the CSA notice and request for comment. There was a paper put out by BC just in February, just before the PDAC convention, which was sort of an update on the progress of drafting the proposed changes. So most of those changes that were published in February are the versions you'll see in June. There's been some changes, but it was sort of a two-step process, which typically is not done, but I think in this case it was useful. So now we're in the still in 2025. The next stage is, okay, we'll get feedback from the public and we'll revise or modify the requirements as necessary. Typically, we then don't come out with a second comment period. We hope that the comments are to the level that we can make modifications, but not have to significantly redraft the proposed changes. The final, date. So the image there of the page, first page of National Instrument 43-101. There's no defined date yet. We're sort of saying 2027 would probably be a time period, but we're not sure, right? Depends on how many comments and things like that we get. So now we sort of come to the point where you and other people that we present to we would request anyways, you take some action because we need your feedback. So we would like people to put in feedback, anything that they want to, or it's not a scripted requirement. The only requirement, it needs to be in writing. It can't be just a voicemail. It needs to be in writing, simple as an email, as long as a very formal comment letter with regards to the comments that people think revisions should be made. Those comments, I've just shown the Ontario website, so it's comments at osc.gov.ons.ca. So that's the Ontario website. That's where the comments can go. And the comment period ends, as I said, in 120 days. So, and as I mentioned earlier, Ontario is required to publish on their website all the comment letters that have been received, no matter if the individual is in BC, if the individual is in South America, and they put in a comment with regards to the proposed changes, those are made public. So be aware that whatever language you use in your comment letter will just be made public. And with that, I think that finalizes my last sort of slide. Again, high level, but hopefully it gives you some of the an overview of some of the proposed changes. You know, it's worth reading through the proposed changes in the rule, the form, the companion policy, and also in the Ontario version where we had to do a cost-benefit analysis. There's additional sort of guidance language in there with regards to some of the proposed changes that's not in the main CSA document. It's in the Ontario only document, but that's useful as well. So this is my contact information. If you have any, don't send your comments regards to the proposed changes to me, send it to the OSC. But if you send it to me, I will just forward it to the OSC so they can put it on the website. So hopefully that gives you a high-level overview of some of the proposed changes, and maybe we have a few minutes to, if anyone has any questions.
Do you anticipate any? I'm sorry.
I was just going to say thank you very much, Craig. Jim, go ahead, ask your question.
I was just wondering if you anticipate any particular kind of pushback on your proposed changes.
I'm sure we'll get comments from some organizations that we haven't gone far enough with regards to environmental social disclosure, that there should be a verification process, that the QP verifies the company's relationship with Indigenous people. I'm sure we'll get those comments. We'll probably get comments with regards to foreign association, removal of foreign association, but I think we've thought it through, and we think we have a response if we get comments in, but maybe there'll be something in the comments that we haven't thought of. So we're not because we did the consultation paper, we tried to make the proposed revisions based on what feedback we got from the consultation paper. Hopefully we won't get a lot of comment. There's already been some comments that relate to the QP definition, basically just like rephrasing the definition. And there's always, the majority of the comments come in the last few weeks. So we'll get a bunch in early October. I think when we had, like I said, the consultation paper, we had 83 comment letters. They ranged from a very short email to over 100-page letter. We'll probably see similar things this time around, but we're not sure, right? We're hoping for not a lot of comments, but there may be a lot of comments.
Michael, go ahead.
Hi, Craig. Thanks for your presentation. It was very helpful. But I have two questions. First one is the acceptance of competent, qualified persons from abroad, Europe, Australia, United States, or wherever, Chile. Is that guaranteed within NI43-101? And the second question would be, how do you see the harmonization with UNFC? Because the qualification regulations for a qualified expert after UNFC is quite different from CP or QP qualification which we have.
Right. So the first question related to, I guess, the foreign associations and their membership designation. So currently 43-101 and in the proposed amendments still has like an Appendix A, which lists foreign associations, foreign organizations that we recognize depending on the designation level. We don't anticipate adding to that list. We always can take submissions, but currently we're not considering adding to the list. So we'll still recognize, engineers in South Africa, AIG members, the JORC registered members, chartered and then chartered professionals for London. So those aren't going to change. So I think that's going to stay the same as we currently have. With regards to UNFC, we don't see our purpose of trying to harmonize with UNFC. CRISCO family of codes relates to disclosure within the capital markets, where my understanding anyways, UNFC is more related to government agencies that to try to understand what mineral capacity they have within each country. So we're not trying to make a framework that would sort of link the two. We're just staying silent on the UNFC requirements with regards to how that system works compared to the CRISCO family of codes and how they work.
There's a question in the chat from Vitor, who asks on the detailed risk-adjusted discount rate in the calculation of NPV, would it be okay to adjust and justify the value used for the beta parameter?
So I'm not an economist, so Vitor, I'm not sure what you mean by the beta parameter.
Hi, Craig. Apologies because I was outside. Indeed, the beta parameter is something that is in NPV calculations and basically reflects the risk associated to an industry or to a project. If it is equal to 1, means that it's basically the same as the market. If it is bigger than 1, means that the volatility of the project or of the industry is bigger than the volatility of the market for that, let's say, commodity. It's something that we use a lot, especially in Europe. I'm not so familiar with the uses outside Europe, but I assume if you just use a different beta, so that's the measure for risk here, then we should be okay. Thank you.
Yeah, I think, thanks, Vitor. Yeah, we tried not to be too prescriptive other than to say the discount rate should be risk adjusted somehow, right? And the technical report would describe how that was adjusted. So the current requirements, we just talk about, disclose the discounted cash flow forecast, which needs to include some type of discount rate, but we have been silent on it. Now we're saying, okay, use risk-adjusted discount rate. How that is calculated or determined, as long as it's disclosed or discussed in a technical report, and as long as it relates to the risks for that particular project, location, stage of development, quality, then that's fine. Again, we're not trying to be too prescriptive. Just concept is don't just use a straight 5% and then leave it at that, or an 8% discount rate.
Okay, thank you, mate.
Any other questions? While you're thinking,
yeah,
Craig.
I
Okay,
have
go
one.
ahead, Anna. Go ahead.
I'm a little bit I don't know how to say it. The UNFC is not only for government, and then I'll add UNFC. What is it? AMREC. That's the adoption of UNFC to the African continent, and we're trying not to promote it only for the use of government, but the AMREC aspect of it. We are saying we're also looking into the small scale miners, because in Africa you tend to have a lot of small scale miner that somehow need to be assisted or need to follow the regulations that is happening in all aspects in order for them to be assisted into the main framework, let's say, of them trying to get resources from the different financial institutions that are there. So this, I'm just trying to say, UNFC or UNFC Americ is not only meant for government entity, but we're trying to make it that people that work in now I'm saying in Africa, they at least follow that, because it's also touched into the SDGs.
Yeah, so I think, again, I think, so basically, National Instrument 4821 is for companies that are within the Canadian capital markets. So it's not necessarily, it's not meant to be used by groups that are small scale miners in South America, Africa, wherever. It's meant to be companies that are, basically listed on a Canadian, the reporting issuers in Canada. So their mineral projects are projects that the company itself is listed on a stock exchange, so it's within the capital markets. I'm sure that the UNFC can be used with regards in certain countries to say for small scale miners, they should, to assist them in their requirements related to whatever jurisdiction they're working. But this is for the Canadian capital markets, right? So I think that's where we're not trying to be in one place for all entities. It's meant for the Canadian capital markets.
Okay, the next question is, it's you have you have, what is it, spoken about the South African, and I'm saying I'm from the Geoscience Council of Namibia, and then how do we kind of like have geoscientists in Namibia that then at least can when they qualify in Namibia can also, we can also have is it it's not an exchange, but what is it that recognize what do we have to do as the Geoscience Council of Namibia? We are the statutory body within the geoscientists in Namibia, so that at the end of the day, we have what should we do as an organization in order for us to be able to say, if our geoscientists coming to Canada, yeah, they can more or less work there or something like that, or recognized.
Okay, so I think what you're talking about is someone that actually relocates from Namibia to Canada,
Yeah.
in one of the provinces, and then wants
Yes.
to work as a registered professional
Yeah.
in Canada in one of the jurisdictions. So that's different than what we don't regulate that. That's the professional registration. That's like Andrea with regards to registered professionals working in jurisdictions. That's regulated by the Professional Geoscientist Act or Professional Engineers Act. So it's a different entity. And there's a whole process for foreign trained individuals to get recognized in somewhere in Canada. But that's not what we do.
Okay, well, thanks very much.
Thanks, Anna. Vitor, you have another question?
Not a question, indeed. It was a sort of clarification following Anna's question on the qualified experts under the UNFC. As you mentioned, I mean, the UNFC was designed for inventory of projects, not only mineral projects, but also energy projects. And in that respect, the requirements for qualification are quite, I would say, different, because they are more open, and the idea is to include everyone. Nevertheless, there is a guidance on competency under the UNFC that is very much aligned with the CRISCO requirements, meaning that if you do or if you intend to use UNFC to report on a project, which, by the way, UNFC is a classification, is not a reporting system, but nevertheless, if you want to do something using the UNFC, there is a strong, let's say, recommendation to follow that competency guidance. And basically it falls, or it goes along the same lines as CRISCO. Thank you. And of course, Anna, feel free to contact me. I mean, several people in the meeting are familiar with the topic, but feel free to contact me if you have more questions. Thanks.
Any other questions? Okay, well, I'm going to take the opportunity. I've got 2 questions, Craig. The first one deals with, if I saw it correctly, still using the term RPEE with reasonable prospects for eventual economic extraction. Some of the other CRISCO codes have and are in the process of dropping the eventual. Are you still planning on keeping it or dropping that as well going forward?
Okay, so that is in sort of the realm of CIM. They own the definition standards related to mineral resource. So in the existing proposed guidelines and proposed rule, we've used the existing term of reasonable prospects for eventual economic extraction. Depending on feedback and where JORC also lands, where CRISCO lands, we may modify and not even use, we may just say, you need to disclose information related to the prospects of eventual extraction, right? And not, or prospects for economic extraction, and not use that sort of language anymore. So we've just put it in as a placeholder, but we haven't made the determination, or CIM hasn't made the determination of how they're going to go. I think they want to align with CRISCO and with JORC when they eventually come out with where they want to land.
Okay, thank you. Then the second question is, here in South Africa, we're getting a lot of pushback from the junior companies in terms of using the SAM codes or any other code that they're allowed to use, because they reckon that it's far too restrictive and they're not able to raise money easily and. Are you finding any similar type of pushback from the junior companies there in Canada?
No, like not with, I guess you're saying companies on the Johannesburg Stock Exchange don't want to follow SAMRAC. They follow JORC instead, or something like that.
No.
No?
The listed companies have no issue with following SAMREC. The
Okay.
junior companies that are wanting to list are pushing back against the use of any sort of code because they are finding them expensive and onerous in terms of reporting obligations.
Okay. Yeah, we don't. I think in Canada, people have adopted the disclosure requirements of 43-101, and actually the rule, something I didn't talk about, but the rule is drafted in such a way that it applies to all issuers, so public and private. So you have a private company, not on a stock exchange, they still need to comply with National Instrument 43-101. So we haven't seen junior or early stage companies pushing back on the disclosure requirements. They may not do a good job, but they're meeting the disclosure requirements, but they don't say we don't want to use National Instrument 43-101 requirements. We don't get that now.
Okay, thank you. Anybody else have a question or a comment? Okay, in which case, Craig, I'd like to take the opportunity to thank you very much for your time and your expertise this afternoon, evening. And I certainly look forward to seeing it when it eventually comes out. And as Craig says, if anybody's got any comments that they would like to submit, please do so. You've got the email address to do so. Okay, so folks, I'm going to then say thank you all very much for your attention this afternoon, evening, or whenever it is. And our next meeting, as I mentioned earlier, is the 22nd of September, when we shall gather together for a presentation by the working groups looking at competent persons, CPD issues, and mentoring that's taking place in the different jurisdictions.
Tanya? Tanya?
Yes, Anna?
I don't know whether Victor has a hand up or not, because it keep going on and off.
No, no, and I was just clapping. Thank you.
Oh, okay. Thanks.
Okay, thanks everyone for your attention. I really appreciate being able to share this with you today.
Thank you. Does anybody have